So I want to start with the indictment. Yeah, we're going to start with the indictment. I also do want to apologize. There are going to be parts of this that I'm not going to be on camera. I still have a very emotional response to hearing some of the things or reading some of the things that the defense attorneys or state's attorneys said. So let's start with the indictment. On April 3rd, 2024, this indictment was given a true bill by the grand jury. As you can see, on or about 1987, which is when the school opened, to about 2014, which is when the school closed, the Family Foundation School, which, just so you know, you'll see it abbreviated as FFS often. It was just easier to communicate that than the full name, which operated in Hancock, New York, marketed itself as a boarding school for children with psychological, emotional, and behavioral issues. This discusses some of the issues that we had at the Family Foundation School. Also, I think it's important to understand that as a family leader, meaning we were broken up into different families. At the time when I was there was about 90 students. We had 3 families when I first got there, and that wound up being broken into 4 as the school expanded. Each family had a family leader that was a male and a family leader that was a female. Paul Geer, was a family leader, meaning he had direct influence on the punishments that we were given inside our family. So food deprivation, which included Geer forcing a student to consume food that was moldy or which the student had regurgitated, severely limiting a student's portions or depriving a student of food altogether for extended periods of time. This was frequent. They used food as a means to control. There were a lot of students that had histories with eating disorders and they would regulate their portions. I could almost understand that, but when you were being punished, you were forced to eat dry tuna. B is isolation, which included Geer placing a student in a small locked room for anywhere from hours to days. In the earlier days of FFS, isolation involved being rolled up into a rug or blanket, which was bound by duct tape or other material for extended periods. In the later days of FFS, isolation involved being locked into a closet-like room for extended periods. In both circumstances, the student had no access to restrooms, resulting in the student being forced to urinate and or defecate on him or herself on the floor. That's true. C is forced physical labor, which included Geer forcing a student to perform pointless but physically exhausting tasks for hours, including carrying hundreds of pounds of rocks between various points on FFS campus, only to be required to return the rocks to their original location afterward. D is blackout. Blackout was used rather often in a lot of different situations. Blackout, which involved Geer preventing a student from verbally communicating with anyone for weeks or months, including family, friends, and even other FFS students, faculty, and staff. That is true. It was common to be on blackout with boys or blackout with the opposite sex. If you had what we considered or called negative contracts, a lot of times they would put you on blackout with the person you had that negative contract with. Family blackout was also a means to control us. If we were being punished for something, they would remove the contact that we had with our family in fear that we would tell our family what was going on. Repeated psychological abuse, which included Geer engaging in table topic sessions, which were lengthy and often vulgar sessions, during which Geer berated and demeans a student in front of other FFS students and faculty until the student admitted, often falsely, to allegations of trivial and irrelevant misconduct. That was a frequent thing as well. A lot of us just wanted the table topic to stop, so we would just say whatever they wanted us to say. F is repeated sexual abuse, which included Geer engaging in various forms of abusive and non-consensual sexual contact with the student, including, but not limited to, forced oral and anal penetration of the student. Now, we'll get to the counts. He was charged with 6 counts, 3 counts of coercion and enticement, and 3 counts of transportation with intent to engage in criminal sexual activity. There were 3 victims. Victim number 1 was a male, victim number 2 was a female, and victim number 3 was another male. I don't plan on naming them. I understand that it's a matter of public record and the documents are redacted. I will try to provide as much context as I can without putting their names in this series. And this is a lot of repetitive information. So the allegations set out in paragraphs 1 through 10 are hereby incorporated by reference as if fully set forth herein. In or on about the summer of 1994 in Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly persuade, induce, entice, and coerce an individual to travel in interstate commerce with intent to engage in any sexual activity for which any person can be charged with a criminal offense. In that, the defendant used the disciplinary sanctions discussed above and his position of authority over V1 to knowingly persuade, induce, entice, and coerce the child to travel to interstate commerce that is from New York to Maine with the intent to engage in sexual activity with V1, for which the defendant could have been charged with a criminal offense including gross sexual assault. It cites the Maine penal codes. Count 2, in or about the summer of 1994 in Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly transport an individual who had not attained the age of 18 years in interstate commerce with the intent to engage in sexual activity for which any person could be charged with a criminal offense, that is, the defendant transported V1, who was then 15 years old, from New York to Maine with the intent to engage in sexual activity with V1, for which the defendant could have been charged with a criminal offense, including gross sexual assault, a criminal offense under Title 17A Maine Codes. Now, so you see count 3. The words are repetitive, so I'm not going to, you could pause and read, but I'm not going to continue repeating them. Victim 1 was assaulted in Maine, taken to Maine and assaulted. Victim 2 was taken and assaulted in Pennsylvania. And victim 3 was taken and assaulted in Canada. It's important to understand the coercion factor that these victims went through, because he used the sanctions, the physical and brutal work sanctions, to break the will of the victim. So this leads us to April of 2024. I decided I was going to do a series on the family school. I had talked about my experience there, but I never really went into depth about it. I started that series because April is National Child Abuse Prevention Month, and this is child abuse. It is institutionalized child abuse. So I did that as like an awareness, and a few days into that series, I did a live, and I did that live discussing sort of like a Q&A about the content that I had put out so far. I ended that live, and when I X'd out of the live, there it was on my FYP from another student from the school with Paul's mugshot. I was like, holy shit. We knew that there was an investigation, but we really weren't given details about, when he would be arrested or that kind of information. So this email was given to us, and I decided to send them an email. In the detention hearing that was held on the 9th of April in 2024, the FBI said that they had that tip line open, and in a matter of 3 days, they got over 80 emails. There were students that did disclose sexual abuse on property or off property. However, because of the statute of limitations, they weren't able to charge him for those. But there are many more victims. I feel like if anything needs to change regarding this type of stuff, it's the statute of limitations regarding child sex abuse. A child does not have the developmental understanding of what the assault or assaults will do to them in the long term. They're not equipped to deal with the consequences of the trauma or how to navigate that. I personally feel like there should be no statute of limitations on child sex assault. But imagine the FBI didn't tell me that they were going to cite a part of my statement in the detention hearing, and my heart dropped. This is that exact email that I sent to the FBI tip line. I am so grateful for these agents. They're so amazing at their jobs. A couple of them I have asked what to do with a situation that I've encountered on the internet. They really have gone above and beyond for us. It's really difficult for me to put into words the energy that Paul Geer gave off, but it was not a good feeling. This is the quote that they read in the detention hearing. Out of all of the staff members that I encountered at the family, I remember Paul to be one of the most sadistic. When it came to punishing or sanctions, I really got the feeling that Paul was fulfilling some inadequacy he felt within himself while taking it out on children. It seemed that he enjoyed the power that he had over us. He felt powerful as he removed any type of self-esteem or confidence that we may have had. That was read in Paul's detention hearing, and y'all can't even understand how that felt, because this is decades later. We have been fighting for somebody to listen to us and to believe us for decades. And it was really difficult to, like, this whole process. When he got arrested, it was really triggering for our survivor community, because even though it's a good thing, it still brings back all of those feelings that we felt back then. So I've mentioned it before because it is a really crucial part to how we got to this part that we could attain any type of justice. The New York Child Victims Act, they opened it up, and due to COVID, they did wind up extending it. It was only supposed to be a year look back, where victims of child sexual assault could go after their abuser civilly. There were many cases filed against the Family Foundation School, quite a few that Paul was actually named in. But that was the beginning of it all, because the FBI was looking for a way to charge him, and through the depositions and that stuff. I do have a couple of the depositions that I've gone through in the Breaking Code Silence playlist. But those depositions where he admitted to taking the trip to Maine with victim one. He himself said, maybe I should have done things differently. And in those things, the FBI was able to connect the dots during the investigation. These are just some of the lawsuits that were filed. There are still a couple open, but this is not normal. It is crazy to me that this many cases, there should never be a situation that this many cases are able to be filed on a school or employees of a school. But I think that just gives people an idea of how many victims there were. And again, these aren't even all of them. This is just some of them. Emmanuel Anthony Argyros is the owner of the school's son, who did take over when his parents retired. I know that I've been pretty clear about how I feel about the staff members that were there and said nothing. I understand that there is a point in time where accountability should be had. I've even gone as far as trying to understand that they were so brainwashed from the cult that they came from. But at some point, you have to see the hypocrisy of the fact that they tried to instill these values in us: accountability, love, honesty, purity. But we're the ones that display that. A lot of things, not that an apology would take it away, but accountability is huge. I've mentioned it before, where the First Times article, the owner's son was quoted saying something along the lines of, "We just want to move on. We don't want to keep going over it." Well, how the fuck do you think we feel? How do you think we feel? Or how do you think the parents of the deceased alumni feel? How do you think the parents of the teen that committed suicide at that program feel? You don't think about that. It's like they don't understand or have an idea of the ripple effects that program had on people. Generational trauma. There's none of that. It's just, we just want to move on. All of us wanted to move on. Don't you think that accountability would have helped in that situation? Paul's detention hearing was held on April 9th, 2024. I did not get the transcripts for the detention hearing, but I did take direct quotes from the important pieces of it. A really important part of his detention hearing was New York's Bail Reform Act. There are things inside that Bail Reform Act that would have or could have dictated that he was free until trial. And when I heard the ADA, Jessica Carbone, when I heard her speak, I knew she had it. It was the first time, I'm getting chills. It was the first time in 30 years that an outsider, it wasn't one of us, because we get it, but it was an outsider. And I was on the call, and when she started talking, I was like, she gets it. She understood. And I'm just going to give quotes in order for the way that the hearing went. And I'm going to do it off camera, because there are parts of it that make me really emotional. This is a quote from the judge explaining the Bail Reform Act and how that has to be applied. The nature and circumstances of the alleged offenses, the weight of the evidence against the defendant, the history and characteristics of the defendant, and the nature and seriousness of the danger to others or the community. Obviously, the government was seeking detention, and the defense was requesting that he be released until trial. I understand that defense attorneys have a job to do, and that everybody is worthy of a defense, but in a situation like this, I would have struggled. I could never work at the federal public defender's office. I couldn't do it, okay? There's just a couple of things that I want to talk about. Ms. LaFex says, what I want to highlight, what I think is the most significant here with respect to the flight risk. Mr. Geer has been living with the allegations of abuse from his time as a staff member at the Family Foundation School since the early 2000s. These allegations of abuse are not new to him. Is that what she said? Because there's a very big difference between the civil cases versus facing life in prison, okay? As early as the early 2000s, Mr. Geer was confronted with some allegations of abuse by former students. Later, in 2008, a former student, John Martin Crawford, testified before Congress. This was highly publicized, and then around 2015, the social media campaigns against FFS and Mr. Geer began to materialize. I don't think that you're worthy to even say his name, and that's just my opinion. John Martin Crawford, it's a testament to him and his work that his name is all over these court documents, all over them. And I think that that's a beautiful thing because he deserved it. He deserved it. He was ready and fighting before a lot of us found our voices. Mr. Geer has also been a named defendant in several civil lawsuits concerning the alleged abuse, and I note this because they are not new. Mr. Geer has been facing all of these allegations for close to 25 years. In the face of those allegations, he stayed in Hancock. Some of those allegations are criminal in nature. Well, maybe he stays in Hancock because that's where he's safe. He was protected for a very long time. As to the danger to the community that Mr. Geer supposedly poses, his history and character weigh strongly in favor of release. He stayed in the same place. He's been steadily employed and has no criminal record or history of drug or alcohol abuse. He has very strong ties to the community. The defense does acknowledge the serious nature of the accusations brought against Mr. Geer. The government has yet to show any evidence that would support those accusations to the extent that the evidence includes alleged victims and former students' statements and stories, but those are insufficient on their own. Nor can the government persuasively argue that the conduct alleged in the indictment is somehow an indicator of Mr. Geer's current dangerousness. The government does not and cannot point to any evidence that Mr. Geer currently poses any risk of danger. Regarding any of the fear that the victims have of retaliation, if Mr. Geer is released, I want to point back to all of these civil lawsuits. It's not just the civil lawsuits, but also the active internet media campaigns. They don't feel like they are afraid of him. It seems very much like they are out for blood. So us getting on the internet and telling the truth about what these people did to us is a media campaign. If you think for 1 second that all of us wouldn't take back the trauma that came with going to this school, you would be really wrong. The state's attorneys were Adrienne LaRochelle, Michael Gadarian, and Jessica Carbone. This is her quotes from the detention hearing, and you will understand what I meant by somebody gets it. I left it on the screen so that y'all could read through. There's some things that I want to highlight and give context or elaborate on, but it's not the entire quote. However, she makes a point. She says, counsel made the point regarding the civil lawsuits that the defendant has not fled from accountability. The government respectfully disagrees with that. A federal criminal indictment is much different than the civil suits which the defendant has been a party of. These crimes carry a maximum sentence of life imprisonment. It's clear that the defendant has worked hard to avoid accountability for his actions. As the court is aware, the defendant is charged by indictment with committing 6 offenses. 3 counts of coercing and enticing children to travel across state lines with the intent to sexually abuse those children, and 3 counts of transporting those same children across state lines intending to sexually abuse them. Typically, coercion types include hypothetical victims and attempted crimes. It's usually an adult or law enforcement agent setting up a fake sexual encounter with a predator. and no meeting actually occurs. But this case is different. The victims were not agents, they were real children. And not just any children. Children whom Paul Geer was tasked with teaching, guiding, and protecting. Worse yet, the encounters were real encounters. The defendant actually took children to other locations where he raped and abused them. They were trips made possible by exploiting the position of authority that he held over children. Children that had no choice. The defendant isn't just charged with its committing these offenses on a single occasion, but rather 3 different victims during 3 separate time frames under equally horrific circumstances. The nature and circumstances of the defendant's conduct is deplorable, no matter how many years ago it was. This is the part that I knew that she had it. I knew that she knew what she was talking about. The defendant used his position of authority over victims 1, 2, and 3 to impose cruel acts of violence on each one of them. Despite the lens that the defendant would have you look at his crimes, they weren't a disciplinary tool for bad kids. They were sadistic and abusive forms of grooming. He used those so-called sanctions to break each victim's will, to isolate each victim from others, to make them more susceptible to victimization, and most importantly, for our purposes, to scare them into silence. To coerce them to bend to his will. And we are here today because the defendant's abhorrent tactics worked. Victims 1, 2, and 3 were scared into silence. Scared for their lives, in the words of victim 1. Each of them kept the full extent of their abuse and the defendant's role in it largely a secret until a few years ago, when Liz Ionelli, another former student from the FFS and victim of Paul Geer's arrest, helped them to understand why they were not alone. But for that solidarity, we would not be here today. If you've kept up with any part of this, you know that there is one of us that has a podcast called Troubled. Liz Ionelli went onto that podcast when the CVA, Children's Victims Act, opened. And she encouraged students to come forward. She filed a lawsuit, and others she helped guide the way to their lawsuits. As you'll see later on in the trial, the way that the defense twisted that into anything other than Liz Ionelli just doing what Liz Ionelli does and help her community. Liz Ionelli is a mental health professional. She is a traumatologist. She was doing what she's always done in her real life for her community and advocating, trying to assist them in the right way to go about it. And they demonized her for it. The trauma at FFS cannot be understated. The trauma of the defendant's actions in the indictment, starving children, rolling their bodies into rugs and leaving them bound on the floor of small dark rooms, forcing them to perform pointless physical labor to the point of exhaustion, truly just breaking their souls, has proven to be too much for many of his victims. Over 150 former students of FFS have taken their own lives in the past 30 years. For example, John Martin Crawford, who testified in front of Congress in 2008 about the abuse that he suffered at the hands of the defendant specifically and the family school generally, took his own life in 2015. Another former student, a legally blind man named Mike O'Donnell, took his life a year later, and it has continued. Another former student took his own life just last week. The trauma of the offenses charged has no time limit for the victims, and neither does the risk he poses to children everywhere. Defense counsel has rightfully stated that the defendant has no criminal convictions or criminal history, and the government agrees with that assessment. I want to be clear about something. A lack of criminal history in this case is not indicative of a lack of criminal activity, and it certainly says nothing about the defendant's character. After the grand jury voted to return the indictment that brought us here today, the FBI set up a tip line specifically for information about Paul Geer and FFS. Since Friday, just 4 days ago, the FBI has received more than 75 calls and emails to that tip line. We have reviewed dozens of emails from former FFS students describing the abuse and the torture that they suffered at the hands of Paul Geer. 3 additional victims have come forward accusing Paul Geer of sexual abuse, and there has been an outpouring of cooperation and support for victims 1, 2, and 3. There are many more victims not named in this indictment. As you see at the bottom, the judge asked her if the emails are indicative of any criminality since 2001. After that section, the federal government read excerpts from the emails and then went on to read statements from the victims. Adrienne LaRochelle reading a statement from a victim. I'm struggling to explain the damage that Paul Geer has caused because it goes so far beyond the 3 victims and 6 counts in this case. This man tortured us. He degraded us. After I was raped at 15 by another adult at the school, he called me a whore and a liar, then watched with glee as I was bound inside a blanket with duct tape and left on the boiling room floor for 8 days. He used his power every day for 17 years to destroy us. We were children, Your Honor. We were his defenseless pawns. My friends, John, Mike, Marissa, and Jay, committed suicide because of the contributory damage that this man inflicted on our survivor community. Our survivor community is hurting right now because our friend, fellow survivor Matt Driscoll, committed suicide this past week at some point after Paul was remanded to jail. This is not old news. It has not ended. Paul Geer is a dangerous serial rapist of children under his control. I was one of them for 993 days. We, his victims, have watched him walk free for 25 years, knowing that he was a violent pedophile, and if he walks free again now, I fear the message it sends to all survivors and the damage that it will do to hundreds, the thousands that Paul Geer has beaten, tortured, and abused. Paul Geer changed us, Your Honor, with the burden of severe emotional, physical, and psychological trauma. I assure you, whatever hardship he endures between now and his trial pales in comparison to the hardships that his victims endure every day. We need to know that you see us, and we have nothing more to fear. If my friends from the family were still alive, I with certainty know that they would have written a letter to you with the same message. Paul Geer is so lethal that kids have unalived themselves to escape him. I respectfully ask for your consideration to detain and remand him to jail. It would be a merciful act. Many of us are weary, and remanding him would ease our pain and suffering. We just want to sleep knowing that he is not in the free world any longer. He used his freedom to abuse, rape, and torture children. A bracelet is not strong enough to stop him. However, steel and concrete may be more suitable to contain him. Thank you, sincerely, Liz Iannelli. Posthumously, John Martin Crawford, Mike O'Donnell, Jay Lavelle, Marissa Benvenuto, and Matt Driscoll. This is victim one's statement. He was the one before me, 1994, and he was assaulted in Maine. Thank you, everyone. This will be the 3rd time in the last month I've traveled from Brooklyn to Syracuse to tell my story and to see the man who haunts me every day in custody and punished for what he did to me and so many others. The thought of him being back on the street again until trial absolutely terrifies me. 30 years ago, when I was 14, I was lured into going on a trip to go fishing and moose hunting with Mr. Geer. I was brought to a house in rural Maine. The sexual abuse began, and after the second day, it became clear to me why I was really there. I was scared for my life, and I tried to escape by taking his car keys and trying to escape to get help. Mr. Geer came outside when he realized I had gotten away. He ripped the car keys out of the ignition and was furious with me. He took my shoes and he put them in the trunk, and he told me if I tried this again, he would kill me and nobody would ever know because I was just another troubled kid. When we went back inside, he put his keys in his pillowcase so I couldn't try to escape again. Now that I'm here today, speaking in front of Mr. Geer, he knows that I'm speaking out against him. The first sign of comfort I've experienced in the last 30 years was at the arraignment last week when I saw him in restraints. That was the first time in a long time I felt like I could breathe again. I felt like I wasn't afraid anymore. The possibility of him being released has been consuming my thoughts since the arraignments, and I've had much trouble sleeping. I do believe that he is still a threat to children in 2024 and is a threat to society and should not be released. I don't think he deserves freedom before trial, nor should he be given any further chances to hurt any more innocent children. I feel compelled to be here today in person and on behalf of the 150 plus that are no longer with us to speak. I'm here to speak my truth and beg the court not to allow this man back into society pending his trial. This is Victim 2's statement from the detention hearing. She's the female that was charged in the indictment, and she was taken and assaulted in Pennsylvania. She was also assaulted on campus as well, but the charging affidavit is for Pennsylvania. Today we are here for your consideration on whether or not to detain the defendant Paul Geer until his trial is set. As I understand it, Your Honor, there are certain criteria regarding your decision. The most important thing is the defendant is an immediate threat to his community and those around him. The answer can be found in the chorus of voices of the living and the dead who've been abused mercilessly by this man. Sexually, physically, mentally, emotionally, and spiritually. I myself was sexually assaulted by him countless times as I was forced to live in the basement of his home where he had unfettered access to me for 408 days. I was a prisoner of his for all those days and the years since. To let this man, this monster, this serial pedophile rapist back into society would be a gross miscarriage of justice. You would essentially mentally imprison his victims until his trial. My question to you, Your Honor, is when do I get to sleep well? Will you send 24 armed protection to my home to keep me safe if you choose to release him? For me to truly regain some type of peace and not feel victimized again, please remand this monster to custody until his trial. He is a lifetime violent child sexual abuser, and he shouldn't be given the opportunity to rape or harm any more children. Please do what is right for our community, what's right for justice, and what's right for me, Victim 2. This is the statement from Victim 3. He is a male. He came in the early 2000s. He was taken to Canada and assaulted in Canada. Good day, Your Honor. I am victim number 3. I want to express my gratitude for finally getting some peace in my life. The arrest of Paul Geer, who ruined my life. I was a prisoner. This has left me with lots of anxiety and panic. This man is a monster who destroyed so many more lives. A lot of my friends who have passed away so young due to the trauma of what he did. Rape, torture beyond words can explain. I am writing this email because I am worried about my safety and other things Paul Geer may do. For him to be out of your custody, it will definitely affect my quality of life all over again. I fear retaliation from him. Please take this into consideration, and thank you for taking your time to read this. Adrian LaRochelle, he was amazing. I can't put into words the gratitude that I feel for the state's attorneys, because they really did such an incredible job actually learning about the school and what we went through so that they had the knowledge to speak on it. After those statements were read, this is what State's Attorney LaRochelle said. When we are dealing with cases as this one is, involving a defendant who through various calculated means grooms victims who are more susceptible to victimization and also into silence, in this case for decades. It is important to note that the defendant's MO, for lack of a better phrase, it is relevant to the history and characteristics because that is what the defendant does. It is what he is charged with. The victims in this case didn't come forward for decades until just a few years ago with the full extent of his abuse because of what the defendant had done. If we're concerned and we're talking about the danger posed to the community, a defendant who operates in a way and abuses children in that way, scaring them into silence, we should be very concerned today about the danger that he poses to the community and to children. We have to look at the defendant's historical conduct to figure out what he is capable of and what he is motivated to do. The indictment is very clear, as are the statements from the victims of what the defendant is capable of. And as Ms. Carbone already stated, the defendant's tactics works. He got away with it for 20 plus years. These are just some more important context quotes. I do want to address the one that Annie LaFex said. She wanted to address the alleged victim statements and underscore that none of those statements speak to the current dangerousness of Mr. Geer. Any fear of retaliation or retribution here is completely speculative and imagined. And I understand that she's got a job to do. I do. But those statements are clear. There has been no proffer by the government or by the alleged victims that they had any current contact, that they have been in contact since the alleged conduct in 1994, 2000, and 2001. Furthermore, Your Honor, I'm sure that I don't need to repeat this, but detention cannot be a retributive act, and two of the alleged victims have suggested that as an appropriate basis for detention. We seek release for those reasons. And God bless Adrian LaRochelle. The conduct outlined in its indictment occurred. It is not imagined. It is real. It happened to these victims who we heard from today, and I want to be very clear about that. That harm, that very real and very impactful harm, was exacerbated by the defendant's violent and sadistic grooming of these victims to keep them silent. That is how the defendant committed these offenses, by torturing these children into silence. If that isn't evidence of the danger posed by the defendant to the community and especially children, I don't know what is. The judge states that he acknowledged the point made, and it is a very impactful one. He believes that the defense is articulating, connecting those long ago events to a real risk in the community today. It is a very real thing as far as alumni and committing suicide. They try to make the argument that, well, we were troubled teens, we had problems anyway. Compounded trauma is not going to ever be a solution for children with trauma. Maybe that's why you should have given us the therapy that our parents believed that we got. Paul Geer was remanded that day. And for a while, we could breathe. He's not the only one, but he was the first. 30 years later. There's no words for the emotions that we felt. The judge wound up on April 12th. This was filed, the judge's decision. And I'm just going to leave it up. Y'all could pause to read. This goes into the Bail Reform Act and how the government was permitted to move for detention based on both the danger to the community and risk of flight. Based on the charging instrument and other evidence presented at the detention hearing, this court finds that there is probable cause to believe the defendant committed the charged offenses, and that he is therefore subject to the presumption contained. The defendant has a limited burden of production to rebut the presumption. However, a defendant's presentation of rebuttal evidence does not eliminate the presumption. Rather, the presumption continues to be weighed along with other factors. The government retains the burden of proving danger to the community by clear and convincing evidence and/or the risk of flight by a preponderance of the evidence. The factors for this court to consider include the nature and characteristics of the offense charged, the history and characteristics of the defendant, the weight of the evidence against the defendant, and the nature and seriousness of the risk to the community if the defendant was released. The defense didn't have many mitigating factors that made him look better than the truth, which is he is a monster. Here, the defendant has met his burden of production of evidence that he does not pose a danger to the community or a risk of flight. The defense used his limited mobility, citing that it would make travel difficult, even though he had no problem traveling across state lines or even internationally in order to sexually assault children. This just goes into the burden of production being met in certain thresholds. As previously set forth, defendant's production does not eliminate the presumption that no conditions of release will reasonably assure against flight or dangerousness. Rather, the presumption remains a factor to be considered among those weighed by the court. To this end, the court concludes that the government has failed to meet its burden to prove by a preponderance of the evidence that the defendant is a flight risk. However, the court finds that the government has sustained its burden to prove by clear and convincing evidence that defendant presents an unreasonable risk of danger to others and to the community, and that no conditions of release will adequately mitigate that risk. The defendant is charged in 6 separate counts, including 3 counts of coercion and enticement and 3 counts of transportation with the intent to engage in criminal sexual activity. On 3 separate occasions in 1994, 2000, and 2001, the defendant coerced, enticed, and persuaded 3 separate minors to take various trips for the purpose of engaging in criminal sexual conduct with them. The indictment further alleges that the defendant transported the same 3 minors across both state and international lines with the intent to engage in criminal sexual activity with them. As the indictment alleges, each of the alleged victims was students at the FFS, a school for children with psychological, emotional, and behavioral issues operating out of Hancock, New York, where the defendant was employed from approximately 1987 until 2014. FFS was a boarding school. Defendant and his wife lived on the school property in close proximity to the dormitories where the students lived. When I got there, my dorm was below Paul's house. That did change, and males were put in that dorm, and then it went back to females. Defendant is alleged to have served in various roles during his tenure at FFS, including music teacher, choral director, and family leader. In these roles, defendant directly supervised and had frequent one-on-one interactions with students. The indictment further alleges that the defendant was an active participant in the application of various forms of corporal punishment and abuse of the alleged victims during their enrollment at FFS, including but not limited to repeated psychological and sexual abuse. He wasn't just an active participant. In a lot of situations, he had a direct role in the sanctions that would have been imposed on students, especially if those students were in his family. I'm not going to read all of it. I'm just going to hit this part. The defendant's conduct is further corroborated by his own sworn statements. During the course of various depositions held in collateral civil actions alleging the abuse of students at FFS, the defendant has admitted under oath, among other things, identifying as a sex addict while at FFS, behaving badly, and otherwise engaging in completely inappropriate behavior with his students, including sexually explicit conversations, screaming and name-calling, food sanctions, and physical restraint. Defendant further testified that at the time he did not believe his behavior was appropriate, but looking back, he agreed under oath that his behavior was indeed inappropriate. The defendant denies subjecting his students to sexual abuse. However, he admitted that he took a vacation to Maine with one of the alleged victims named in the indictment and recognized that he shouldn't have done that. So this is what I was referring to earlier, when there were certain things that were said in indictments that led the FBI to be able to connect the pieces and the dots in order for him to be charged. And some of that evidence came from Paul's very own statements. As of January 2024, defendant was employed working remotely from home as a team leader for a call center. Defendant indicated that he has recently been terminated from this position as a result of the criminal allegations against him. He volunteered with a youth leadership organization during his tenure at FFS. I just want to really quickly make the difference. Children that you see once a week or a couple of hours a week for a music lesson or something like that is very different than the students that we were. A lot of us, when we got to the Family Foundation School, we had already had layers of trauma. We were already broken. We lived there, so there wasn't the risk of the students that you're giving musical lessons to be able to tell their parents was a lot smaller. The family school protected Paul. They gave him free reign because that chorus brought the school in money. They allowed him to do what he was doing for decades because they were motivated by greed. The coercion and enticement of children is itself a crime of violence and presents obvious concerns regarding danger to children and the community in general. The defendant argues that the remoteness of the alleged crimes and the lack of intervening criminal conduct in the interim is significant to establish a lack of dangerousness to the community. Although the court recognizes this might be some evidence to establish that defendant would not pose a safety risk, the court considers this small comfort in light of the seriousness of the crime and the degree of harm it inflicts upon its victims. Furthermore, the court finds the government's proffer as to the risk of danger the defendant continues to impose on the community to be compelling. Although the defendant denies engaging in sexual abuse, he has admitted to engaging in other completely inappropriate behavior with minors, including that of a sexual nature, which admissions corroborate many of the allegations contained in the indictment. Furthermore, the defendant proffers that he has been living with the allegations of abuse from his time as a staff member at FFS since the early 2000s. It is concerning to this court and indicative of the continuing danger the defendant presents to the community, that despite the defendant's knowledge of these allegations, clearly of a criminal nature, he continued to seek positions of authority and supervision over children. Between 2008 and 2015, the defendant volunteered with a youth leadership organization, where his duties included coaching a youth choir and traveling out of state with students. Defendant was permanently banned from volunteering with this organization in 2020. The defendant also maintained a live webpage advertisement for musical lessons as recently as the pretrial investigation by the probation department, advertising services to those ages 13 plus. The defendant's continuing efforts to seek out positions of authority and supervision over minors, coupled with the psychological grooming and victimization he is alleged to have utilized to coerce his victims, provides a clear and convincing evidence to this court of a serious risk of danger to this community. Moreover, the government proffered evidence of more than 75 tips regarding abuse at FFS by defendant through and including 2013, the year before FFS closed. Equally disturbing is information suggesting that over 150 former students of the FFS have taken their own lives in the last 30 years. One individual in particular testified in front of Congress in 2008 about the abuse that he suffered at the hands of the defendant at FFS. The alleged victims have stated they continue to fear retaliation from the defendant and fear for their safety due to his continued presence in the community based on his past threats of violence and retribution against them. Defendant's threats may have been made years ago does not weigh against the detention in this court's opinion, but rather evidences the defendant's success in grooming and threatening his minor victims into silence for so long, and the continued risk that he poses to the community in having done so. I have carefully considered possible conditions of release that would adequately address the danger that the defendant presents, and find that no condition or combination of conditions would mitigate the risk of the defendant's further efforts to prey on vulnerable children or assure the safety of other persons in the community. It is well established that home detention and electronic monitoring may be insufficient to protect the community against dangerous individuals. At a minimum, defendant's own statements evidence that he has been unable to recognize the risk posed by his egregious and inappropriate conduct toward and with children in the past. While the defendant proffers that his recent participation in deposition conducted in civil actions is a positive factor, this court believes that his evident, complete lack of awareness of the seriousness and potential criminality of his alleged behavior is a factor that counts against him in terms of his present danger to the community. This, coupled with the defendant's admitted sex addiction and the serious allegations lodged against him, suggests the defendant's inability to control his behavior even if he is released with strict conditions. And they remanded him. He spent months behind bars, and they released him on house arrest a few months later. I do want to, I'm going to read this. It's an email. It's a personal email. And I also want to say that the FBI and the victim advocates and the resources that they have given to us during this has been amazing. I just want to read this email. I'm not going to screenshot it, but it's just an update. It says that, after he was released on house arrest, a lot of us struggled, obviously. But this person had a conversation with the prosecutor. I told them in no uncertain terms that letting him go home is a slap in the face to all of us, but especially his victims. The prosecutor offered me some information about how that all went down. Apparently, he had appealed his bail several times and was denied several times. It was then taken to a higher level court, which was a panel of 3 judges that let him go. They told me that those 3 judges are purely academic and don't take to the human aspect of things. So they were all looking at it as if he's done nothing wrong in the last 10 years. The good news about this is the judge who will be at the trial is one of the judges who already denied him bail. He has already gone through the files and all the mountains of information pertaining to this case, and he does absolutely see the human aspect of things. It is taking so long because they are doing everything they can to make sure that this case is ironclad and there is no way that he will ever see daylight again. The laws have changed a lot in the last 20 years, so they have to go by what the laws were then. It will be a jury trial. The testimonies will be heavy and difficult to hear, but necessary to illustrate what he did and just how much of a monster he really is. You know, I thought about it, right? The human in me says, well, at least his wife had some time with him because he will die in prison. He is a very unhealthy man, and he's got a hefty sentence. But then I have to remember, there were trophies in the closet, in the bedroom of her home. She worked at that school. She knew. And she made a decision to stay. He had pictures of victims in his closet years later. So at what point do we, the victims, cut off that humanity side of us? I try my best not to move with bad intentions, but there are certain types of people that I just can't allow myself to have that kind of grace with, and they fall into that category. She was married to him, or is currently, took the stand to defend him. I would never be able to stand by that. Nope. And I find it really hard that she didn't know. I do. Because she knew about all the other abuse. Why would this be any different? I appreciate y'all. This is going to be a heavy series, maybe because of my personal involvement, and it really hurts my heart that we've lost so many, and all because of the actions of a handful of people. It's crazy how one situation can alter so many lives. When my son was first born, I left on bad terms because I walked away. And for a long time, I considered getting married at the chapel that they had on the property. And it wasn't till years later that I understood trauma bonds. And I took my son there. He was a baby, maybe 3 or 4 months. We went up for Family Day. The chorus would do like a big production. And I was thinking about that because why would I do that? The person I am today wouldn't have done that. But at that point in time, I was still very much in this mental state that was not well. or healed in any way, shape, or form. And the damage, it's like endless. It really is the parents that of the children that have died. And I know I talk about John Martin Crawford a lot. And I really wish that he was here to see how far we came. Because it wasn't that long ago that it was just a couple of people working on behind the scenes. The internet made it possible for us to get on here and unapologetically show what they did to us. And I don't know how some of them look themselves in the face. I would never be able to live with myself if I caused a fraction of the trauma that they caused children. We were children. That they told our parents they were gonna help. Some crazy shit, y'all. It's some crazy shit. I haven't figured out how I'm gonna break up the trial yet. I'm sure that I'm gonna have to take breaks in between because today was a long one. I'm gonna put myself in a nice bath, feed my cats, and keep it moving. All right? I appreciate y'all, and I appreciate that people. I appreciate that people want to hear it, because for so long we were ignored, and that means, I'm sorry, that means a lot to us. The fact that this platform helped other students get to that trial, it means something to us. Because then, nobody would have done it. Nobody was listening to us. We were just other troubled teens. And I'm so grateful. But I'll see y'all soon.